Namaskar, Adab, Sat Sri Akal, and a big hello to everyone. Way back in 1868, Mr. William Gladstone, the then Prime Minister of the UK, made a very profound statement when he said, "Justice delayed is justice denied." And this is the topic today which we are going to discuss. And in India, in the last many decades, the arrears in the various courts have surged so much that the statement made by Mr. Gladstone seems to be most relevant for our country. Now, the delay in justice actually causes two things. One, it deprives an individual of a rightful claim and a justice for his claim. And secondly, it actually does a big damage to the belief of people in the justice system. And this cuts at the very roots of the democratic setup that we have in our country. So keeping that in mind, don't you think it is so ironical that in a country like India, where we work on a premise that unless proved guilty, every person is innocent, whereas we find that in our jails, more than 2/3 of the people are under trials and they are still awaiting, the verdicts of the courts. This seriousness of the mounting arrears in the courts reminds me of two very important incidents. One was in 2016 when the then Chief Justice T.S. Thakur, while addressing the Chief Ministers and the Chief Justices of various states, actually during his address of about 45 minutes, broke down 3 to 4 times when he was referring to his inability to check the mounting arrears in the courts. And he also lamented very, very strongly the fact that the government has not been too helping and supportive in this. And no wonder the Honorable Prime Minister Shri Narendra Modi, who was sitting as one of the participants, he rose and made an unscheduled speech for 2 to 3 minutes, in which he said that, and he rather assured the whole nation that significant steps would be taken to correct this menace. I am also reminded of a very recent statement, say in July 2021 by our present Chief Justice Shri Ramanna, when he was addressing a judicial conference, and he made a mention of the fact that presently we had 4.5 crore pending cases across various courts. And when he said 4.5 crores, actually there were more than 3.9 crore cases pending in the subordinate courts, about 59 lakhs in the 25 high courts, and over 69,000 cases were pending in Supreme Court. And mind you, he was speaking in July 2021. By December 2021, the figure had reached 4.6 crores. And if I'm not wrong, we should be at a sniffing distance from a mark of 5 crores. So this is something very, very serious. And no wonder in 2019, the retired Supreme Court Judge Markandeya Katju said that at the given pace and the given wherewithal that our judicial system has, it would take 350 years to clear off the arrears. So this problem therefore is very, very serious, and we need to deliberate on this in detail. First of all, we should discuss what is meant by our judicial system. In our common parlance, we would generally say that the courts are actually the institutions which constitute our judicial system. It is not like that. The whole judicial system comprises 3 very important organs. One is the police, the local police across various states. The second part is the prosecution, and the third part is the courts. Now, as we all know, the police does the primary investigation and does all those things that we keep hearing, and then they develop a charge sheet when they find a prima facie case made out against the accused. The prosecution is where the trial actually is happening, and when I say prosecution, I'm referring to the criminal side of the judicial system, wherein, as you all know, in every criminal case, state is the party which fights the case against the accused, because it is always believed that every crime is committed not against an individual but against the state. And then comes the third part, which is the courts, wherein when we say subordinate courts, we are talking about these small courts at the district level, right from a magistrate's court to a district and session judges courts. Then we are talking about the higher judiciary, which comprises 25 high courts now, and the apex court is the Supreme Court, which is in Delhi and which is the top court of the country. Now, what is the problem with these three organs? Actually, therein lies the root for this problem. The problem with the police department is, let me tell you, the police department traditionally is mandated to do two major activities. One is the beat, which in Hindi we say gasht, and the second is crime investigation. The first step, which is beat or gasht, is aimed at avoiding crimes, and crime investigation is when the crime has been committed. Police should be doing a very decent investigation, a foolproof investigation, so that a case is made out and it reaches the court. Now, the problems with police is, you would be surprised to know that there are close to 6 lakh vacancies across India of the police personnel in various states, and whatever force we have, you would be surprised again to know that close to 40% of that force is taking care of the bandobast or the VIP duties or the special arrangements that are made from time to time. Nothing wrong with that, but I think the prime function is investigation, which should not suffer. When it comes to the prosecution side, you'll find that the public prosecutors and the assistant public prosecutors, etc., there is hardly any upskilling happening there, and oftentimes APPs and PPs are no match to the private lawyers that are engaged by the other party. In the case of the courts, we find that there are huge vacancies, and you would be surprised to know that till a few months back, even Supreme Court had 9 vacancies out of the sanctioned strength of 34. In case of high courts, against a sanctioned strength of 1080, 39% vacancies are there, which is close to 400. And when it comes to the subordinate courts, situation is much worse, where one finds that 5,000 plus vacancies are there. So these are and then besides the vacancies, poor infrastructure, again, and lack of technology support till now, although many of the courts are now e-governed and technology is helping the courts, but much more needs to be done. Now, what should be the corrective action? In this regard, the police needs to pull its socks, in the sense that all vacancies have to be filled in. The investigation has to be given top priority, and people involved in investigation should not be put anywhere else. Together with that, timely investigation, taking care of the forensic lab, etc., remains very important. And you would be surprised that since the investigation doesn't happen well, it leads to a very low rate of conviction, which means, and if I could give you an example, in India, on an average, 1 out of 4 rape accused gets convicted. So which means that 3 people out of 4 accused of rape, they get acquitted, which I think is very alarming. And in some states, only 10% people get convicted on heinous crimes like rape, which is again, I think, a matter of great concern. And with a low rate of conviction, you would all agree that it is like incentivizing criminals, because then they get the idea that since they are not going to be punished, they would be motivated to commit crimes again. Now, so this is about the police. For the prosecution, we need to actually do upskilling training, and we need to actually have specialized sessions for the prosecutors so that they remain updated and they don't mess up the trial when it comes to the courts. For the high courts and the Supreme Courts, we've already discussed that there are so many vacancies. This needs to be spruced up. The 5,000 plus vacancies, and more than that, at the subordinate level, we have a great amount of, a cry for more court halls or the, courtrooms. Though in the last about 4 to 5 years, close to 4,500 plus courtrooms have been added by the present government, but much more needs to be done. In addition to all these suggestions, I would also like to bring forth two very important Law Commission reports. The 230th report of the Law Commission, which was published in 2009, made the recommendation that adjournments sought by the lawyers should be strictly controlled and all adjournments should be as per Order 17 of the CPC. Other than this, there was another suggestion which meant that all similar natured case, they should be clubbed so that when one decision is taken, it actually takes care of all similar cases. Other than this, the report said that the decision should be so convincing and decisive that it should not lead to further litigation on related matters. The 2014 report, which was 245th report of the Law Commission, made again, it lamented the fact that India still has about 12 judges per million population. It should be ideally 50. And it made a mention that in Japan it was 28 per million. In Australia it was 40 per million. In US it was 108 per million. And in France it was as high as 124 per million. So that was the expectation. It also said that the retirement age of subordinate judges, which is the district judges and down below, it should be raised to 62 years because maturity makes better judges. Now, with all this background, the one point that comes to my mind is that yes, justice delayed is justice denied, but justice hurried is justice buried also. And therefore, it is a tightrope walking. The judges would be well advised that although the areas are to be cleared off, but the quality cannot be compromised. And I am reminded of Lord Macaulay's great statement made about 150 years ago when he said about the judgments that the judgment should have uniformity whenever they can have, they should have the diversity whenever it is necessary, but certainty they should every time have. So I am very sure the collective wisdom of our lawmakers, executive, the legislature, the judiciary, the bench and the bar, the camaraderie, and more than anything else, the media, the public opinion. I think the collective wisdom of all these institutions is going to guide our, people further. And we are going to check this menace before it becomes unwieldy and it, hits at the very roots of our democracy. In the last few years, there have been signal improvements, as I already have mentioned, in terms of more courtrooms, more IT-supported courts, more vacancies being filled in at the High Court, Supreme Court and the subordinate level. But this is just the beginning. We have to make concerted efforts in the years to come. And I'm very sure with all these efforts, India is truly going to emerge as a rule of law state where democracy survives and prospers because there is a very, very healthy adjudicatory process and system available. We'll keep coming with such interesting topics in future also. Kindly remain connected and promote this channel. Please take care. Namaskar.